Hello everybody, my name is Anju Balakrishnan. I'm a legal intern of LEXIS and Company, and today I'm here to talk about the writ of Mandamus under the Indian Constitution. In my previous video, I mentioned about writ of habeas corpus, where I mentioned that there are 5 writs provided under the Indian Constitution, which is the writ of habeas corpus, the writ of mandamus, the writ of prohibition, the writ of certiorari, and the writ of quo warranto. Today's video will be focusing upon the writ of mandamus. The writ of mandamus basically is a writ issued by a superior court to a lower court or to a governmental entity, to an officer, in order to correct their past conduct or their failure or omission in order to act a particular way, to complete particular legal responsibilities that are entitled towards them. Public corporations as well as courts can also be issued the writ of mandamus. But we must understand that the writ of mandamus is remedial in nature, and it depends upon the discretion of the court as to whether or not it should be issued. So basically, it is not a writ of right, but it would be issued upon the discretion of the court if the applicant can prove to the court that some sort of just question or utilitarian would be answered by the writ. There are some grounds in order to issue the writ. The first one is that the applicant or the petitioner must have a legally recognized right, and this right must be compromised or violated in any manner. The second one the second ground is that the right that is violated must be violated by a public authority that can take place either by crossing the line between powers and responsibilities, or by omitting to do a particular duty or act responsibility by the legal requirements provided. The third one must be that the failure or act of performing a legal duty mentioned by the applicant. The fourth ground in order to issue a mandamus is that the writ should be filed in good faith, and the applicant should not have a hidden agenda or an intention as to why they filed the writ. The fifth and the last ground is that the writ of mandamus can only be given if the applicant has exhausted all other remedies or other methods in order to gain legal remedies. If the court finds out there was another way in which they could have gained legal remedy, they would not be issuing the writ of mandamus. We must understand that Article 32 of the Constitution mentions that the Supreme Court has the right to issue writs. The writ of mandamus cannot enforce governmental policies, but can be used to challenge a statute that violates a basic right. There are 3 types of writs under the Indian jurisprudence, which is certiorari mandamus, anticipatory mandamus, continuous mandamus. Certiorari mandamus is basically certiorari and mandamus together. The distinction between certiorari and mandamus is that certiorari allows for judicial review of a matter that has been previously tried by a lower court and determines the jurisdiction has been exceeded, while mandamus considers whether the jurisdiction has denied the right to exercise. If certiorari is granted, then the order of the lower court or tribunal will be nullified. However, there are certain cases in which the writs of certiorari and mandamus goes hand in hand. The second one is anticipatory mandamus. In numerous cases, both in India and in other countries, the court of law has held that the mere threat of having one's statutory fundamental rights being violated, or an anticipatory omission of a public authority's duty or responsibility is considered to be insufficient grounds in order to issue a writ of mandamus. Basically, it means that anticipatory mandamus cannot be taken because just anticipating that your fundamental rights may be violated, anticipating that a public authority may not do its duties in the future, cannot be considered as a promising ground as to why we should issue the writ of mandamus. The third type of mandamus is continuing mandamus. Continuing mandamus basically means that in some situations the court may determine that just issuing a writ of mandamus is not enough, but continuous monitoring of the public authority is required to ensure that the verdict is properly carried out. So basically, in such situations, the court supervises the public authority against who the writ was issued and tries to ensure that they do in accordance to the judgment of the court. So hence we can understand that the writ of mandamus is basically regarded as a legal tool in order to defend the public's interest as well as the rights guaranteed by the Constitution and other laws of the land. Basically, like a habeas corpus, the writ of mandamus also tries to ensure and protect that the rights of the people are protected. It's also a useful instrument in order to hold the state or public accountable uh, and require them to follow the constitutional and statutory commitments. With the writ of mandamus, we can ensure that the state as well as the public officials are accountable for their actions. So basically, the writ of mandamus is a right provided to the citizens in order to hold the public authorities accountable for their actions. I hope that you could understand what writ of mandamus is. If you like the video, please press the like and subscribe button in order to get more law related videos in the upcoming days. Thank you for your time and understanding, and I hope you have a wonderful day ahead.